Good evening, everybody. We're back. They let us back on for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my trusted co-host, Julio Velo. What's going on, my friend?
Another day in paradise. We got Longhorns, Aggies, Bearcats. Put them all together. It's a mistrial waiting to happen, maybe?
Well, it's a table full of misfits, that's for sure.
It's for
We got three returning guests to the program tonight. One who we actually, our co-host, my co-host here, had to actually loan him the tie for this evening. He's very bitterly upset about it. Mr. Mike Driver back at the show.
Glad to be back, Jimmy.
Begrudgingly, he says. We're also welcoming back Brandon Ball. Brandon, thanks for joining us back on the program again.
Thanks for having me back.
And finally, last but not least, Jordan Lewis. Good to have you back on the show as well.
Thank you for having me.
We got a lot to get to tonight, ladies and gentlemen. We got a full house of lawyers, so it's going to be kind of hard to get a word in edgewise here. But we are going to open up the phone lines about 8:30 if you want to get in on the conversation. 713-807-1794 is the number. Twitter, use it, folks. We have it so you can communicate with us. It might be the best line to get a word in tonight at HCCLA_TV. So you can hit us up there as well. I've got it right in front of me. Send us messages. It's been real quiet. Lot to get to tonight, guys. We got a lot of mouths to talk here, so I want to jump right into it. We had three different cases where we got verdicts in this last week. We saw a mistrial in Bill Cosby's case. We saw an acquittal in Geronimo Yanez, also known as the Philando Castile murder case, acquittal there. And then Michelle Carter gets convicted for texting her boyfriend or a friend about how to kill himself using carbon monoxide poisoning. Three very different cases, three different jurisdictions, all very high profile and all very controversial. Each decision in and of its own right. Let's start with Cosby, because I kind of saw this coming down the pipeline. In fact, I told people don't be shocked if there's an acquittal. And a lot of people said, why? Because he's a celebrity? I said no, because when you're trying to prove a 20-year-old sexual assault case, and it's a he said, she said, those are difficult cases to prove. And,
But-
I mean, it's not surprising to me that there was a mistrial in this case.
But why? Didn't they introduce either, I guess, from a deposition saying that he said something of the effect of, I have 3 friends here that'll help you calm you down, and they were Quaaludes. And wouldn't that be enough, you'd think? What says you?
I mean, look, obviously, not enough, not for some jurors. Not enough agreed with you on that.
What are y'all's take on it?
It was a mistrial. Mistrial is ordered by a judge, not a juror. So I don't know what happened there. I think that he lives to play another day.
What is a mistrial?
Well, so the judge apparently determined that after spending, I think they spent about 4.5 days deliberating, that this jury was not going to come to a unanimous verdict. I've seen online an interview with one of the jurors who spoke to a reporter on condition of anonymity. And so I guess we really don't even know that he was a juror. But one of the things that struck me was that according to him, the initial straw poll that they took once they went back after hearing all the evidence, every juror was not guilty on every count. And then somehow, as I think you said earlier tonight, they reversed 12 Angry Men it into 4.5 days later. It was 10-2 on 2 of the counts. Although, and I'm speaking from memory here, but I think on the count where they claimed that she was so incapacitated as to be unaware of what was going on, they were actually 11-1 for not guilty on that count. But the first and third counts were, the count he gave was 10-2 for guilty at the end. But like I said, what caught my attention was their initial straw poll. You had 12 people voting not guilty, and that wasn't the end of it for some reason.
Did Bill take the stand? Do we know?
He did not.
Wow.
He did not.
Wow. You try this case?
Yeah,
This stuff's scary. No way.
try this case every day of the week.
How can you not with
2004 case.
exactly?
Question about her credibility. She called him afterwards multiple times. Now was first day of the trial.
Yeah, how do you not bring up the issue of a cash grab in a case like this?
Was it brought up?
I don't know.
Bias and motive?
I've had other things going on other than Bill Cosby's life, but how do you not bring up the fact that this is a very successful black man in America, and these people just want money?
Wait,
I don't know. I don't know.
I guess it's in the pudding. Was that what it was?
I mean,
You had that one ready.
there was,
I wanted to take you to practice that.
Things just come to me, you know? They just come. They just come. I'm like, oh, I
You
should
have
say
been
that.
standing in front of the mirror ever since
Say
the
that.
verdict came out.
Jordan, what says you?
well, I mean, the fact that there was deposition testimony means necessarily that there is a lawsuit surrounding this stuff. And I mean, when these accusations began to come out, I think a lot of people, the first thing they thought of was Kobe Bryant. I mean, being a multimillionaire black man does not make an unattractive target for this sort of allegation, true or not.
Yeah, I agree. The first thing I think of when I think of Bill Cosby is Kobe Bryant.
Hey, the man. No,
but I mean, look,
In terms of a rape allegation where he is saying, that never happened. That never happened. They're targeting me because I'm a convenient target with deep pockets.
I do believe the issue in Kobe Bryant's case was the level of consent, though.
But still, deep pockets, though.
but
I mean,
that's
it's-
And that's also the issue here.
Had he been
always
had
the
he been a
issue.
guy with $50 in the bank account, that accusation would not have come forward.
But see, that's the problem. But the problem is the issue of consent. That's the overriding issue, it seems like now, in most of these cases. And one of the biggest problems that I had was I read an article, and I can't remember whether it was New York Times or Newsweek or something, but it was talking about how this was the reason this happened is because we all can't agree what rape is defined as, and because of the rape culture in America. And that was the biggest BS article I think I've ever read. I mean, it comes out right after the mistrial is declared, okay? So one, I think it's irresponsibility on the part of journalists, because one, you haven't talked to any of the jurors yet, so you don't know exactly what the jurors were deciding on. And here this guy is already making assumptions that these people didn't know what they were doing, that they were deciding it based on rape culture and not on the frickin' evidence. I mean, that was the most offensive thing I read after this mistrial.
I would agree with his central tenet that a big problem in this case is that the word rape is becoming untethered from any definition.
That's right.
But I believe that for, I'm guessing, the exact opposite reason that he does.
I'm sure.
Because sexual assault is a thing. It has a definition. It
has a legal definition.
It has a legal definition. And the fact is that in our culture, there is a push to move away from that definition. And I think it's causing problems beyond just the courtroom. If words don't have a definition, you can't have a conversation about that word because no one is talking about the same thing.
Yeah.
I was surprised that of the 40 other accusers, one of them was allowed to testify in this case, because I wonder how they came to the decision of just allowing one and maybe not two or three. If you're going to allow one in there, 2, 3, or 4.
In Texas, they'd all be allowed to testify at this point.
They really would.
What was their reasoning? Do we know? Right. So in Texas, are there protections for an accused for those types of things?
There used to be. The general rule is if you're saying that this guy did this thing on this date, you can't throw in a whole bunch of evidence about how he did similar things on past occasions. So if he did it then, he must have done it now. The glaring exception now under Texas law is in sexual assault cases. They are allowed to offer what we call propensity evidence to show, well, he's done it before, so he must have done it this time, right? And I think it's a huge problem.
Now, in propensity evidence, are you talking about like 404B evidence that is specifically tailored to sexual assault cases for all sexual assault cases, or are you talking about propensity evidence in terms of indecency by contact cases and stuff like that?
I think he's talking about, there's certain things, I think he's talking tailored, you're right.
Yeah, the Code of Criminal Procedure has, within the last 8 or 10 years, been amended to specifically allow evidence of prior similar acts that never in a million years would have been admissible prior to that law coming into effect to statutorily override 404B.
Is it the Code of Criminal Procedure, or is it the rules of evidence that we're talking about?
The Code of Criminal Procedure has been amended to override the pre-existing rules of evidence. Because the rules of evidence, 404B, has always been, with very, very few exceptions, you cannot offer evidence of prior similar bad acts in order to help convince the jury that this guy did it again. But in sexual assault cases, and now that I say that, it may be limited to sexual assault of a child, but I think it's sexual assault cases. The Code of Criminal Procedure has been amended to override the rule of evidence and allow the prosecution to offer prior similar conduct in order to convince a jury, in order to help, specifically in order to help convince a jury that that's what happened in this particular case.
I also happen to know that it's in indecency cases too. Not just if you have an allegation of indecency in one county, they can bring it up in a trial in the other, even though no charges have even been brought
Exactly.
up.
Wow.
Exactly.
Oh yeah.
That's
That's
This
horrible.
is where we're going.
Right.
That's horrible.
That's what I'm getting at, is that in Texas, my understanding, and the change that has happened since I've been practicing law is that the state of Texas can now offer evidence of prior allegations of similar sexual misconduct in order to help them prove a questionable case of sexual misconduct that's on trial now.
The prosecution's saying they're coming back after Bill.
Within a year.
What says you? Fair, not fair?
Well, they have the right to try the case again. They always have. I question how quick they're going to do it. I think it's because...
Now, Brandon, don't duck the question. Is it fair? Is it not fair?
No, I think it's fair for them to try. You talking about from Bill's point of view? Probably not, but the state has it out. They can do that. They can try the case again.
I mean,
Get
that's
another shot at the apple.
That's always been the rule. After a hung jury, if the state decides they want to come at you again, they can come at you.
They can do
again.
it.
You didn't win, but they didn't win, but they also didn't lose.
I think Bill Cosby's lawyer's from Texas, I think.
And what
St.
is
Mary's.
this? Did you see that he's going to go around and hold some town hall seminar on sexual assault?
Who is?
Bill Cosby.
Yeah, if he's pending retrial, my client's not going to speak
Yeah,
to anybody
no.
but me. pending-
No.
Yes, he and his PR team says they're going to go around and do town halls on sexual assault cases.
That's
I
a
will
bad
bring
money
my
grab.
That's a bad
I will
idea.
bring
It's a
my
real bad
Fat
idea.
Albert
That's a
lunchbox
bad
to
money
have him
grab.
sign it. If he comes Tuesday.
Dude, the guy needs to go disappear is what Bill needs to do, bro. He needs to disappear.
I mean, that's just the dumb. If he really is going to do that,
What?
Yeah.
So it begs the question, so it's been a significant amount of time. Is this justice? I mean, is it fair? I mean, it's been a significant amount of time, but
I think it comes down to who you are and what you believe. As far as a prosecutor is concerned, if he genuinely believes that Bill Cosby raped this woman, then yes, it's fair. He didn't get a conviction this time around. He still has an opportunity to try to get another one. And the allegation is that a woman was raped. So, yeah, I mean, and quite frankly, even if it wasn't Bill Cosby, I think on a felony sexual assault case, if the state manages to convince 10 jurors, there's a very good chance that they're going to retry your client, period. But with all the press they've gotten, I think it makes it almost a slam dunk.
I just think it's going to be very hard for them to get a conviction on this kind of case where you have no physical evidence. It's all his word against hers. I just don't see how they get 12 people to agree.
I don't know. I disagree. I think we've all seen cases with evidence as weak as this where the jury just comes to, well, why would she lie about something so serious?
I'm going to side with Jimmy on this one. There is not a way that this can be fair. And in terms of justice, justice was defined to me most adroitly by an old retired civil attorney. And he said, a guy named Steve Zimmerman, he owns Lacombe d'Or and Zims.
the cologne?
Lacombe d'Or is a hotel on
Name dropping over here.
Yeah, I'm name dropping an old established civil attorney. He said, justice is getting what you want. So what is justice in this situation for Bill Cosby? He gets acquitted, walks out, everything's good. What is justice to the people that are accusing him of this? That's the question, because they already tried to get money out of him. They may have already received money. I don't know. I am not part of his legal team, and I honestly sleep well at night without even thinking about Bill Cosby.
Does the pendulum swing a different way if the complaining witness is white?
I think she was.
How many are
Yeah.
black?
Was she white?
Yeah.
I thought she was black.
No, I don't think
I
this one
thought
was.
this one, because it was 40 of them. I thought this particular one.
The real question is,
Precautions.
if she'd been a child at the time, I think we see a much different result.
Yeah.
I mean,
About that.
child sex cases where the only
Well, but I mean,
evidence
look,
is what
yeah,
she
there is
says
that
happened.
one. There is that one that allegation they have out in California where the girl was 15 at the Playboy Mansion, where but that's fertile cross-examination.
But
What were you
what
doing
I'm
at the
talking
Playboy
about-
Mansion at 15 years old?
I'm talking
you know?
about I'm talking about your run-of-the-mill, and I say run-of-the-mill. It shouldn't be, but these happen far too often. A young woman comes forward as a young adult and says, "Hey,
Yeah.
when I was 12, this guy molested me," and the only evidence to support her claim is what she says. People go to prison in Texas on that exact case on a fairly regular basis.
That's
Every
unless
day.
they hire somebody that's at this table, and then they can have a Coke and a smile and sit down. Sit down. You know?
Except there's not a person at this table that would walk into the courtroom on a set of facts like that and be confident that they were going to win.
I don't know.
That's scary, bro. That is scary. That is scary as hell.
I got to be honest with you. I mean, I don't think on any case, if there is a lawyer who is truly 100% confident they're going to win the case as soon as they walk in, I have yet to meet that person.
Oh, they
And
work
he's a
for
liar.
the Travis County District Attorney's Office
We'll get to that in a
and
second.
Adam Riposa's contempt trial.
We'll get to that in a
Yeah,
second. But let's
yeah.
switch gears. Let's table Cosby till probably the retrial. But I want to go to the murder case of Philando Castile because we finally got a verdict there. The officer, Geronimo Yanez, was acquitted in that case. And big video release that we finally, the only video we saw up until trial was the Facebook video post-shooting from the girlfriend. Not his wife, but his girlfriend. Now, after the acquittal, the full video from the dash cam has been released, shows the whole story, and we get an acquittal.
So here's what I'll say, and I actually brought some numbers from the Bureau of Labor Statistics.
Came prepared.
I came prepared. The verdict here should not come as a surprise to anyone who is paying attention in our country. And to my mind, it all comes down to one single issue, and that is every single person in this country is deluded about how dangerous it is to be a police officer. I've got here a list of 20 jobs in this country, according to the Bureau of Labor Statistics, that are more dangerous than being a policeman. Some of these shouldn't be surprising. Loggers, fishermen, those are really dangerous jobs. It's more dangerous to be a trash man than a policeman. So according to the Bureau of Labor Statistics, the most recent numbers that they have available are for 2015. In 2015, 11.7 police officers for every 100,000 working full-time were going to die in the line of duty. Now what's interesting about that is that nearly half of those were going to be traffic accidents. If you take out the traffic accidents, you get down to 4.68, and just as a baseline, the average across the country is 3.4. But even if you include all the traffic accidents, the list of jobs that are more dangerous than being a police officer are construction worker, mechanic, maintenance man, taxi driver, groundskeeper, construction labor. Groundskeeper. More dangerous than being a policeman.
You get hit by a rake or something?
You
Fall under a lawnmower, I mean, whatever.
You're done for.
Fall into a hole. And farmers are twice as likely to die on the job as a police officer is. And the fact of the matter is that I think the problem comes into play in two different places in a case like this. Number one, police officers are unreasonably on a hair trigger because they've been trained that they're doing the most dangerous job in the country and that any one of us might shoot them at any time, which is total horseshit. Sorry, pardon my French.
Beep, beep.
Beep.
Here's the dumb button.
Wasn't me, Jimmy.
The other issue is that in the same way that police officers are trained that the job that they're doing is more dangerous than it actually is, the people who make up a jury are conditioned to believe that he's out there doing a dangerous job, he's having to make split-second decisions. I'm not familiar with the law in
Minnesota.
I'm not familiar with the law in Minnesota. What I know in the law in Texas, what the jury would have been asked to do is decide whether, number one, that officer genuinely believed that he was under an immediate threat from Mr. Castile, and secondly, and most importantly, whether that fear was objectively reasonable. I think the numbers show that it was not. The problem is that what that jury believed, and I think what most juries anywhere in this country are going to believe, is that because that job is much more dangerous than it actually is, that just about anything becomes reasonable, and reaching for anything becomes a threat. And so I think what this case shows more than anything is that because of gaslighting about the dangers of the job, police officers have license to kill. A writer that I read pretty regularly refers to it as the reasonably scared cop rule.
Yeah, but I'm going to piggyback on Jimmy's statement earlier of do we actually have confidence in our decisions? No, we don't. And if I was representing a cop in that situation, I would go into trial, battle ready to explain to my client, you're going to prison, dude. You're going to prison for a long time. You're going to get hammered. And the fact that this guy went in with a set of cojones that I guess are just monumental and said he was afraid. Ignore what you see. He was afraid for his life, and I want you to find him not guilty, let him go home to his family.
It's great.
That guy walked his client out. And I think that was something worth appreciating, at least from our perspective, of a guy that's accused of wrongdoing and us holding the state to their burden. The state maybe dropped the ball. I don't know. I didn't pay attention to the actual workings of this trial. But I think that this attorney pulled off a monumental victory in the face of the videos that have come out on social media and whatnot. That right there is enough to send somebody to prison.
I think he did, no question, he did a great job.
Anytime
he walked his client.
Anytime you get an acquittal, you've done a great job.
Oh, yeah.
Because the odds are stacked against you, regardless of whether you represent a police officer, which there are a lot of lawyers out there and a lot of people who believe that juries are conditioned to acquit cops. I mean, look, if a prosecutor is actually prosecuting them, then that prosecutor believes that they should be convicted. And look, I mean, the reality is, we know if the state says it, more often than not, the jury's going to agree with them, whether it's a police officer, whether it's a regular person or not. So, look, I mean, the fact that that lawyer went in and got an acquittal is impressive in and of itself.
Two things. Two things come to mind when I think about it. The first thing is, I didn't read the transcripts about the trial, but I would imagine at some level, like what Mike was alluding to, that he did some version of Us Against the World, Give Us a Chance, with a little guy, don't believe what you've seen on television, look at the facts, look at the evidence, give my guy a shot. He walked into it with some version of that. And the second thing is, I get asked the question all the time as a criminal defense attorney, as somebody who's African American, as somebody who sees these shootings happen and people get acquitted, like, is there a conflict for me? And the way I answer that is this: the frustrating thing for criminal defense attorneys, the underlying frustrating human thing is that we know our clients, for the most part, don't get half the luxury that these people get. That's the frustration. That's the frustration.
I think that's where the numbers come in. If this had been just two guys who had an argument and all of a sudden one of them reached into his pocket and he got shot, that guy goes to the shooter goes to prison in a heartbeat. The reason clearly the defense lawyer did a good job. He got his client acquitted of murder when we see a murder on videotape. That officer's fear that he was about to be attacked was not a reasonable fear. It was maybe an understandable fear given his training, and it was understandable that the jury thought that it was reasonable given their conditioning. And like I said, clearly the defense lawyer did a good job. He walked his client for a murder where the shooting is on tape. The question, though, is reason. Why does a cop get a benefit that our clients would never in a million years get? And I think it's because we've been conditioned for about the last 40 or 50 years that these guys are out there putting their lives on the line for us every day. And they do, but no more than our trash men.
But I disagree with that now, because the media, particularly in the last couple of years with all the police shootings, I think it's much harder to defend a police officer now in a shooting because people are now conditioned to think that all of these police shootings are unjustified and the police are just out there killing people. And so I think it makes it much more difficult, actually, to defend a police officer in this day and age because of what the media has done with it.
I actually think it's different. I think it's people going back and supporting police officers even more because of the outcry, because of what's saying. Whenever there's any type of jury selection, the question is asked, do you believe cops, what's going on now? It's more overwhelming that people still believe in police officers. They still get the benefit of the doubt.
I think he's right. And I think what we have seen over the last few years is some erosion of that trust. But that's like getting a 10% discount on a Mercedes-Benz. I still can't afford the thing. I mean, when the trust in the police started as high as it did when all of these videos of all of their misbehavior began coming out. They were starting at such a privileged position that even the hits that they've taken have not gotten them anywhere near to playing the same ball game that a normal criminal defendant is playing when he shot somebody because he was afraid for his life.
I'd take this case to trial over the Cosby case any day of the week.
And twice on Sunday.
I would take the Cosby case to trial if Cosby paid me.
I would take
I want
any of
that
these
Cosby
cases
money.
to trial. I would take any of these cases to trial if you
I'd
got
take.
the money right.
Well, what says here? You go Cosby or you go
Cosby.
You go Cosby?
All day, all day.
If I had to, if my concern was winning the case and I had to choose between Bill Cosby's case and a policeman who shot a black man, I would, if I wanted to win the case, I would take the policeman who shot the black man.
I take the
every
police
day of
shot
the
the
week
black
and
man
twice
every day
on
of the
Sunday.
week, man.
I mean, that's.
I do because I mean if we're talking.
all right. Bill
Win the
Cosby-
case, get paid.
Oh, if you think that officer's lawyer didn't get paid, he may not have gotten paid Bill.
I want to know who that guy
Okay.
is.
Well, in Harris County, you're not even going to trial. You're going to get
You're
no
not
bill.
going to get.
No, they would probably get true billed here.
They just indicted an officer today, former
Okay.
officer. The just came down today. I saw it was a guy who retired after there was a home shooting or something like that. I didn't see. I just saw the headline come across.
Was he
but
on
they-
duty or?
But he wasn't acting as a cop, right?
Huh?
He wasn't acting as a
I
cop.
didn't see the whole
okay.
thing. I just saw former HPD cop who recently retired was indicted today. I didn't,
okay.
I didn't get it. I just saw the headline come across as I was walking in here.
If it was on duty, according to Randall Cowland, that would be the first in like a string of 250 shootings out of HPD where they were no bill.
There recently, I mean, it just came down yesterday too. I think in Milwaukee or somewhere up north, Wisconsin, a black cop shot a black individual in the arm. The individual threw the gun over the fence and then falls to the floor. Then the cop finishes him off. That officer was
40
acquitted
years.
too.
Oh, well, he wasn't acquitted?
Yeah, no, he was acquitted, and so it makes me kind of think to myself, maybe it's a police versus people thing that's going on. Like, I'll represent if the cops are walking, cops versus Cosby, I'm gonna represent the cop every time.
not-
But let's
It's not-
remember, police are people. So
They are people, but they're
people
they're
are in
privileged
those
people.
uniforms. We can call it privilege. We can call it whatever it is. And you might say that it's you did say that it is the nature of an overinflated sense of the nature of the job is so dangerous, but it is a freaking dangerous job because you're going to have.
It's less dangerous than being a taxi
Is it less dangerous than running drugs for a cartel? Maybe.
No,
it
it's
is.
less
I don't
dangerous
know.
than being a taxi
It's
driver
actually
or a trash
it's
man.
have
more
all the data
dangerous.
on
Mike is making those Jeff
I
Sessions
think here's the
comparisons.
point. I think here's the point, though, and this is where the reasonableness comes into play, is that when you're a police officer, and look, I mean, if you look at the video, the dash cam video, I mean, his reaction is one of, "Oh my God, what did I do?" And he let out a bunch of expletives that, Jordan, we can't say on the air, just to remind you.
I apologize.
But I mean, when you look at his reaction, I think that it is reasonable to believe because I can kind of see it, and I'm not trying to say that all cops are justified in what they do, because I don't believe that. But on this specific case, I can understand if you get into it, you've pulled somebody over, you don't know what you're walking into, especially, now this wasn't late at night, but I can see how the perception is there that police who walk up to an unknown suspect in a car they've just pulled over, they don't know what they're getting into. They don't know who's in the back seat, who's in the passenger seat, till they walk up there. I mean, there's a lot of angst in that. And yeah, some of these guys may be trigger happy, PTSD suffering guys. I mean, who knows? But the fact is, if you were put in the position of, okay, I'm out here, I'm going to walk up to a car at 3 a.m. and see what's going on. Really? You don't think there might be a dangerous situation going on?
No,
I think I see how if you're a good lawyer, you can paint that picture to a jury
Absolutely.
and justify the reasonableness of his actions.
Absolutely, and here's the thing: given his training, and that's actually part of my problem with this. I think a huge part of the issue and a huge part of the problem is that these officers are mistrained. They are taught that their job is far more dangerous than it is, and so they conduct themselves as though they are doing a job that is much more dangerous than it is, and it's going to lead to errors on the side of citizens getting shot for reaching for the document they were just asked.
And therefore not objectively reasonable.
It's not objectively reasonable. Subjective, I have no doubt that in the moment that cop pulled the trigger, he thought that guy was reaching for his gun. The question then becomes, was that a reasonable fear? my answer is a hands down no, objectively. Given his training, I can see how he got there. And that's my gripe, is that these guys are being mistrained. They're being trained to believe that they're soldiers in a war zone when they're supposed to be public servants in peacetime. And
What says you,
it
Brandon?
leads to dead people who don't need to be dead.
Reach for
reset
your
ourselves here
taser
real
instead
quick.
of your gun.
Right.
We just hit the halfway point of the show, ladies and gentlemen. So if you want to get on this conversation, 713-807-1794 is the number. Twitter is still up. Nobody has tweeted in to us. So
Hey, check this out.
let's get it going here.
Do it. I want you to tweet right now. Do it. No, it's okay. Go ahead.
Eat them up, cats.
You gotta
Is that working?
You gotta address the president directly.
No,
Right?
well, go tweet. Go ahead and do it.
Eat them up, cats.
Right, right.
We're going to tweet, and we're going to tweet ferociously.
That is an amazing impression. We've now had 2 impressions tonight.
He does a great Samuel Jackson.
I'm sick and tired of you not tweeting.
Yeah.
That was good.
It involves cussing. It involves cussing.
It's hard to do a Samuel L. Jackson and do it correctly when you can't
Right.
drop the F-bombs.
Yeah.
Last case I want to get to before we get into Mike's personal life here in a second. This Michelle Carter conviction.
Deeply disconcerting.
It really is. It really is. So this girl gets convicted for texting her friend about committing suicide. The guy ultimately does it, and she's now convicted through text.
Yeah.
Through text.
It's deeply disconcerting.
I'm not sure what's more
Yeah.
disconcerting, the fact that she's convicted or the fact that her lawyers chose a bench trial.
That's
for this.
exactly what I was talking about.
I didn't put this in front of a jury.
Are
you insane?
I will say this. From the stories that I've seen, the evidence was pretty strong that she was pushing hard for this young man to go ahead and go through with what he'd been talking about doing for months. I agreed with the decision to try it to the judge because when you try a case to the judge, you are putting all your money on this is a legal issue, this man is trained in the law, he will see that while what she did was disgusting and reprehensible, and anyone who knew this young man should be angry with her, that this is not what our law was designed to handle. You put those sorts of decisions in the hands of a judge and not in 12 people who are not going to be able to see past the crying mom who lost her son far too young. So I don't disagree with his decision to go to the judge. I am shocked that the judge decided that telling a young man to do something that he's been talking for months about doing makes her liable for the decision that ultimately he made.
It's mind control, bro. It's mind
No,
control.
So there's this movie called Indiana Jones and the Last Crusade, and they're trying to find the goblet
that Jesus drank out of.
the Holy
right?
Grail,
The Holy Grail.
that Jesus would have picked, and you're saying go for the big old jeweled one because that is obviously the King of Kings, and you take it and the guy dies, dissolves into a skeleton and screaming, and
she died.
Clearly, in
and she
retrospect,
died.
it was the wrong
And she
call.
died
What did
a
the
horrible death.
caretaker of all of those grails say? You chose poorly.
What says you, Brandon?
I mean, clearly in retrospect, he chose wrong, but this case was a question about, there was no dispute about what she had done, there's no dispute about what happened, there's no dispute about the sequence of events. The question is a young woman criminally liable for telling this kid, yeah, dude, you should just go ahead and kill yourself?
I disagree with almost everything you just said.
Well,
Didn't
I
you
thought,
say yeah?
I thought there
Stop,
was,
Brandon. Why don't we hear
looking at
Brandon?
the article, I thought there was some dispute because she actually didn't text him. During the actual event, she actually spoke to him about it. He got out the car. He said, I'm going to get out of the car. Then he got back in the car after she told him to. What it was a couple weeks after he died, she texted her friend saying, I think this is my fault. And so her lawyer was mainly arguing that, how do we know it really happened like this?
Well, she mind controlled him, didn't
Or
she?
even getting in that, how do we know her rendition of what happened is correct?
There you go. I think that's right. Yeah.
So it's not as clear.
So it is
this
a
cuts-
factual issue.
The real issue in this case is the difference between criminal liability and moral culpability.
And you
Correct.
gotta
What she did-
have facts in order to have criminal liability, right?
You gotta
Why
have a
take
law.
that to a judge? Why
You gotta
not?
have a law that says that she's criminally liable if these things happen. This is the first time in the United States that a person has ever been convicted of telling a potential suicide, hey, it's okay, go ahead and do it.
Jordan, I foresee you have a very lucrative career as an appellate judge. That sounds like no harmful error here. That everything looks okay. I can understand.
No, I would reverse
what's
this.
going.
I would reverse this in a heartbeat
How?
because what she did is morally reprehensible, but not a crime. She did not cause his death. He caused his death. That's why we call it a suicide and not a murder.
Oh, so you would not show deference to the trial court's findings?
No, not in this case. This is a legal issue, not a factual issue.
I misspoke.
What says
You
this?
do
All
not.
of the
What says it? What says it?
As an appellate
All of the
judge.
attorneys who've spoken on it within the Massachusetts area have basically said this judge stretched the law, which means created new law.
Right.
You can't do that.
He
at the trial
created a
level.
new law.
You can't do that at the trial
No
level.
person in the United States has ever been convicted of, hey, you know what, just do it. This thing you've been talking for months about doing,
Right.
just go ahead and do it. No one has ever been convicted of that.
Question.
And here's the real problem. She was convicted of manslaughter. Either she committed murder or she committed nothing. She intended for him to die, and she either caused his death or she did not.
What about conspired in and aided and abetted in his death?
A murder is someone else. You can't murder yourself.
But but isn't okay? So maybe you. I know there's books where there's laws in the books where you can't kill yourself or you attempt to kill yourself. That very well.
Well, you can. Let's be clear. It happens.
Right. Well, you can.
But you can't get charged with
You
murder.
can't be charged with it.
The real problem is, number one, I think the real issue is criminalizing attempted suicide is terrible policy. Because what does a mother do when she walks in and finds her child on the floor, a suicide attempt? I can get him help, but if I get him,
He might go to
she's
jail.
left with a decision. Or let's say it's not a mom, because mom, that's not a question, but a friend. Well, he wanted this, but if I call the cops, he's going to get arrested. It's terrible public policy. Criminalizing suicide is about as worthless as you can do. Because either he commits the crime and he's not subject to prosecution because he's dead,
Yeah.
or he fails and he didn't commit a crime.
I see the problem here as what we're really doing, because she was convicted of involuntary manslaughter.
It,
Okay.
It doesn't fit.
Reckless and
because-
wanting conduct, yeah.
Yeah, but this is where we've been stretching and over-criminalizing our laws to now criminalize negligence, okay? And instead of having the traditional intent or culpable mental state like we all learn about in law school, the mens rea, as they say, now we're bordering into almost a civil analysis of negligence and whether or not you take remember the old eggshell plaintiff case?
Right.
You take the plaintiff as you find them kind of thing. I mean, and that's almost what this is, because you're saying,
Exactly.
look, this guy was suicidal to begin with, and now you're liable because you sent him text messages or made a call encouraging his otherwise predisposition to do this.
Our law
And in
has
some form
always-
or fashion, isn't a First Amendment attorney chomping at the bits? Because it just goes up. Doesn't this eventually conflict in some form or fashion?
Well, but there is a category of unprotected speech that's speech. I don't remember the word, but speech that's No. Hate speech. Hate speech is protected.
Fighting
They
words.
just said so this week.
This week.
Hate speech is
integral-
protected. Oh yeah, the slanted the thing.
Speech
Yeah.
integral.
That came out while you were practicing your Bill Cosby
Right.
impersonation.
Speech integral to criminal conduct is not protected speech. You and I can't freely conspire to go commit a crime. That's not free speech. That's the exception that this would fall into. I don't think a First Amendment analysis will work here. However, our criminal law has always put down a clear line between word and deed for exactly the reason you were talking about. If it could be a crime to really, really hurt somebody's feelings, well, I might say the exact same thing to these three different guys and commit a crime once, but not the other two times, because that's all about how sensitive are you as opposed to the thing that I actually did. There's a difference between word and deed.
But in this situation, it's a crime because she was convicted.
Yes, absolutely.
But let me pose this hypothetical to
She's
you.
a convicted criminal because she was convicted. That doesn't mean that a crime happened. That's what our appeals
Ooh,
process is.
fair enough. Hey, innocent doesn't
Just
mean not
because you
guilty.
did it
Innocent don't
doesn't
mean
mean
not
you're
guilty.
guilty.
So let me ask you this.
No. The question is, assume that she did every single thing that the prosecution says. That doesn't mean she committed a crime.
Doesn't mean it's a
Quit
crime.
Aren't
making
there
me fall
cases-
in love
but aren't-
with you, Jordan Lewis.
Aren't
Quit
there
making me
cases
fall in love.
where you and I are doing a bunch of heroin, and I'm not shooting you up, but I'm shooting up and you're shooting up, and I'm telling you, go ahead, keep it going, and you keep it going, and I keep it going, and you die.
That's right.
Hasn't there been cases where I suddenly am a defendant in a case?
And those are problematic because it's. I mean, it's not okay. Our criminal law wasn't developed after we gained our independence from England. We inherited all their stuff. They've been looking at this stuff for thousands of years, and for thousands of years, we've had a difference between what you said and what you did. And with very, very few exceptions, what you said is not a crime. We look at what you did. This is a case where if she had said those exact same things to someone who was stronger or less inclined to suicide or any of those things, we don't wind up where we are. It's results oriented, and no question what she did was disgusting. Her parents are probably humiliated. His parents, clearly she is the worst human being on the planet. None of those things make her a criminal. The law is what it is, and this judge stretched the law in ways that it's never been stretched before, and that's a problem.
So let me ask you this. All right, Brandon, you got the Cosby, you got the text messages, and you got the cop killing. What case you take?
Text messages.
Ooh, wee.
Moral reasons?
All day.
Text messages.
You say
If
text?
I want to win.
What says
take
you,
the-
Mike?
Cosby's paying.
You go Cosby.
Well, let's talk. Let's switch gears a little bit and talk about the case that Mike is actually on.
What?
And what you've been dealing with all week. And I appreciate you joining us, given all you've been through
Thank you.
this week, because you've had a car crash too.
Yesterday, yeah.
It's kind of like a metaphor for your life this week. I think.
Pretty much.
It feels
Just
like. But you are representing Austin attorney Adam Riposa,
Yes,
who
sir.
is currently. Well, I don't know where he is, and I don't expect you to comment on that at this
He's in
point.
Austin.
Okay.
No, the KPS was lifted.
Okay. And he is in the midst of a contempt trial in Austin. You're defending him on it, I think, with another lawyer as well, right?
Steve Brand
Yeah.
is lead counsel on that. I help Adam with a slew of other things, but in this particular case, I am sitting second chair to Steve Brand.
So Adam is famous or infamous, however, whatever side of the fence you're on with him, criminal defense attorney up in Austin. He has been held in contempt once before.
Twice.
Twice?
Yes.
Okay. I did not know about the second one.
Yeah, what was the second one?
He misscheduled a trial date in, I believe, Bell County, and it was just a fine he paid.
Okay. But the first one, he actually did jail time on.
Yes, the judge that's sitting on his contempt hearing now
Heard that
was the judge that ruled on that one.
Yeah.
Judge Paul Davis.
So let's talk about what exactly got him into this current contempt situation.
It was a voir dire examination and a .15 or higher DWI in County Court 5 in Travis County. Nancy Hohengarten was the judge, and he was questioning people about their ability to consider the full range of punishment, and in that he was asking if people could consider 0 days and a $1 fine, which is within the range of punishment.
Except that it's not. On a DWI, the minimum is 3.
72 hours.
Reread the statute on that, because maybe the legislature dropped the ball, but on a .15 or higher,
You're
it's
right.
a Class A misdemeanor.
Right.
That's
No.
0.
Yeah.
Oh,
No, you're right. 'Cause it's
I
That's
mean,
a very particular.
I only worked in the legislature and as an appellate attorney for, I don't know, about a decade. But there is this doctrine called implied exclusion.
No, you're
And
right.
when they don't say term of confinement minimum, then you go by whatever they say. This is a Class A misdemeanor. It's a Class A misdemeanor, which means 0 days to a year. And so he was, and there was no question about this,
Right.
by the way, from the state or from the judge. Everybody agrees. So we're going into that voir dire with this understanding.
Sure.
Okay. He was asking several veneer members about whether or not they could consider no confinement in a case where a BAC was .15 or higher, as is his, I guess is his standard modus operandi in these kinds of cases, where
Conformity therewith.
yes, pretty
we
much.
talked about earlier.
He likes to. He's not necessarily contesting guilt, innocence. He just wants to know who's going to be a good person on his jury for the least amount of time that his client's going to have to spend in jail. And Nancy Owen Garden has expressed vociferously her objection to that style of lawyering. We actually have a case that was decided by the Court of Criminal Appeals in Ivy, it was Ivy, where a judge, Nancy Owen Garden, decided to probate a sentence of like a couple of
Confinement,
days.
right.
A couple of days.
Thanks to
She
him.
probated it for a year.
Thanks to that case, it fundamentally shifted the way
Thanks to that
DWI
case-
law is practiced. Yes.
Exactly. Yeah. Now we all go into a trial thinking that it's not the jury's purview at any point in the game, really, to assess the punishment. And recently,
So what happened, Mike?
all right.
What happened?
So he basically said that the judge wasn't being fair when she directed a veneer member to say that he could consider the full range of punishment, thereby rehabilitating a client or a veneer member from getting themselves excluded for cause. And that's
the gist of it.
that's the gist of it.
And
He
so
got a
I've
little
read that-
upset, and he did say, within earshot of the jury,
Something like, I can't get a fair trial here. You see what's going on.
She called him to the bench. He said, no, this is a public trial, and I want them to know, I want these people to know how difficult it is to get a fair trial in this court.
So that's what he's
That-
being held in contempt for.
She has 5 different counts of contempt at 180 days apiece, potentially.
And as I understand it, he's not, or they've ruled he's not entitled to a jury on this case.
Yes, without sentencing him. Now, Jimmy, do you know when you're entitled to a jury on a contempt?
Well, I used to think I knew, but after this case, I don't think I know anymore.
If you were sentenced to 181 days, you get a jury. Anything over 180 days. Now, what did we not have going into a pretrial conference on this contempt?
You didn't have a
Notice?
We didn't have a sentence.
Well, 180 days is the max. It's
5 different counts of contempt.
I think it's potential confinement, so you can stack the contempt hearings. Is that
You
what?
can,
the jury-
180 days, 180 days, 180 days, 180 days, 180, 2.5 years is what he's looking at.
right, but the Supreme Court cases on the right to a jury are triggered by the actual sentence.
There was no actual sentence.
Right.
Ooh,
But they're
interesting.
retrospective. So you can be facing more than 180 days, but if you didn't get a jury and you didn't get more than 180 days, your right to a jury was not.
That's what we're talking about. Now, Nancy Owen Garden has absented herself from this little proceeding. So, Government Code 21.002, subsection, I think, D, doesn't apply to Nancy Owen Garden's contempt, where upon issuing a sentence for a contempt of court action, you then present a motion to the court, and upon proper motion, you are released on your personal recognizance. That gives you notice of the next step. So I sentence you to 181 days, or just 180 days, or 2 days, or just $1. You pay me $2 and you can go. Do you think we would be here if she actually sentenced him to a weekend in jail and $10? No, we wouldn't.
He'd
We
be
have
out-
two
he'd
and a
be out
half
of jail and had
years
paid his
hanging
$10.
over Adam Riposa's head.
So it sounds like this whole thing, from the judicial standpoint, kind of sounds like a little bit of a dog and pony show that they're putting on, and the fix is already in.
I mean, you say dog and pony instead of kangaroo court.
Same thing.
And I recognize your deference to the Travis County system, but I have never
Maybe I
really
should say that
seen-
they are trying to put up the patina of fairness because they are actually conducting a hearing while.
Patina of fairness is actually it's a very adroit description of this, because a patina means that it's been caked up over years, and they did this to him the last time, which really, they completely ignored the government code.
Yeah.
They completely ignored actual procedure. That's why he didn't show up on Monday. He didn't show up on Monday because, first of all, he's stressed out because he thinks he's getting railroaded, and he got his heart racing for notable reasons. And he didn't show up later in the day because
Well, we didn't get into why he didn't
Yeah,
show
he
up.
showed
yet,
up
but-
because of the doctor. All right, he had to go to the doctor.
Yeah, he's sick. Or not.
you don't understand the amount of stress that is going over
Yeah.
a lawyer. This is a lawyer.
Correct.
Who represents clients.
Correct.
That is being railroaded by the system.
And to be fair, this is also the same lawyer that takes glee in towing the line and occasionally stepping over the line without getting smacked for it. So,
When's the last time he didn't get smacked for it?
have you seen his commercials on YouTube?
That's something you can
I mean,
take
the
up
guy-
with
look,
YouTube.
look,
So,
No, I mean the guy relishes.
Does he
the guy
sacrifice
relishes
his
flouting laws.
First Amendment rights because he's a lawyer?
No, but I also think that everybody at this table recognizes that after the same exchange with a judge, none of us would be facing contempt proceedings because none of us have spent the last several years daring those judges to do something about his behavior.
We always say that our clients' past come back to haunt us, and
we had a phone.
no, we don't.
No phone. So what should the judge? Okay, so the judge issued a warrant for him without sentencing him first,
Correct.
and therefore,
Giving him official notice of when and where to appear.
There was
And/or
actually
notice.
no summons.
so it was premature.
Well, I mean,
He wasn't obligated to be there.
there is that, but the capious aside, there were other issues that were going on. I moved for a recusal. I needed Adam actually there to prove up my motion to recuse because it did have allegations of how he was being railroaded. Now, he was also required to be in Georgetown for a contested hearing. That same morning, I moved for a continuance until he could be available. He was in the Travis County Courthouse Friday afternoon. The judge denied my motion for continuance, had me go forward. I called witnesses talking about Judge Davis's demeanor and potential bias. I couldn't really get there, though. So after I lost my motion to recuse, they slapped me with sanctions. They slapped me with sanctions for defending a person charged with criminal contempt, a criminal defense attorney being slapped with sanctions by a district attorney special prosecutor. Does that not irritate you? Does that not reek of something that is inherently unfair? And then, on top of that, they asked for $450 an hour. $450 an hour.
I'd be interested to see a single voucher where that judge agreed to pay a lawyer $450 an hour on a criminal.
This is the thing.
They don't even
This
put that
is
murder
Judge
lawyers
Kirkendall.
Yeah.
Judge Kirkendall, I believe, is a civil judge. He's a retired civil district court judge. He was appointed to hear the recusal hearing. Of course, he's going to deny my continuance. He's going to deny my motion to recuse. He's going to. I knew that as soon as I walked in there. I did not anticipate winning that motion. And then the state says, I didn't know to file sanctions earlier, but now that we've won, we're going to file sanctions. And he orders to have a sanctions hearing a few days later, pursuant to the rules of civil procedure. I just received notice on Friday. We had the hearing Tuesday afternoon. And I had Steve Brand get on the stand and say, what would happen if I didn't file this motion to recuse? He said, you would have been found ineffective. Okay, so I'm either found ineffective or I have to pay them $450 an hour? What?
You tell me what government employee makes $450 an hour.
It's
at-
roughly $900,000.
Hey.
I'm sure there's some, but
Where
they
do
don't
I
make it above
apply,
board.
man? Jesus.
Jesus.
Let's, man, we got a couple more things. Let's get this call in here.
Oh, yeah, cool.
Because we're running out of time on this show. Again, too much to get in. Hello, thanks for calling Reasonable Doubt. Hello?
Hello.
Yes, hi.
Hi. I just wanted to make sure you knew at least one person was watching your program. I had two comments. One has to do with how difficult it is to win a conviction against a cop. It's difficult to even get an indictment against a cop.
Yep.
And then additionally, the problem seems to be that often if they are convicted, it comes under the label of negligent homicide and not murder, which from what being an avid watcher of Law and Order, from what I gather is a slap on the hand, like a year's.
I mean,
Is that correct?
well, compared to a murder conviction, yeah, criminally negligent homicide is a slap on the hand. I mean, it's going to be, for anybody who's in law enforcement, it's the end of a career. There are some stiff punishments that go along with it. And if I had a client charged with criminally negligent homicide, I'd fight as hard as I could to make it go away. But yeah, compared to a murder, yeah, it's relatively speaking a slap on the hand, but it's no small thing.
What says you, caller? What's the feel? What's the tone of people versus cops or cops versus people? What's the feel out there?
Well, my view is somewhat slanted because my experience on a grand jury is what made me a little more acutely aware of feelings. So I don't know that I can give you an idea of.
Ask me if you know about any cops.
Yeah. Did you participate in the simulation where you see the officer and then you have to make a decision if the officer should shoot this person or that person? Did you take the
shoot or no shoot?
The shoot or no shoot simulation?
I did, and it was great fun, I might mention.
So, going back to what we were talking about earlier, I guess could you or could you not see that it's objectively reasonable or not reasonable for Yanez to have believed that his life was in danger? That's a tough one.
Well, but that gets
Well,
to
it is a tough one, and I can just say that from the point of that simulator, it does subliminally sway you to the police officer's position, simply because you're down there and you're seeing this, and somebody's running at you, and whether or not you're afraid, it really is somewhat off balance. But I think, who can say whether he was afraid or not? It really doesn't matter. But I do know what I mean. It doesn't matter in that you can't really question if you're afraid, you're afraid. But one thing I do remember from that day is the police officer who was demonstrating it for us and eventually had us participate. He was talking about the fact I had mentioned that I had a situation one of the situations I was in with the simulator.
Caller, I'm gonna have to cut you off because unfortunately we're running out of time here on the program.
Call next Thursday.
But let's get you back. Please call in next week. I apologize, but we are running out of time here.
All right.
Thanks for your call, though. Man, guys, we ran long despite your tie issues.
I know, right? This is the worst tie I've ever seen.
It's a nice tie.
It is a horrible tie.
You were still able to offer insightful opinions.
It's still going on. The KPS was lifted this morning. He had a psychological examination that was originally denied on Monday, ordered by the judge. I don't know how that's going to turn out. The psychological examination is.
Well,
all right.
We'll bring you back on.
If you need to.
We're going to talk about it.
If you need to.
That's all the time we have for tonight, ladies and gentlemen. Thank you for joining us on Reasonable Doubt. Brandon Ball, Mike Driver, Jordan Lewis.
We're all throwing up signs.
Eat 'em up, cats.
Eat 'em up.